Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3053. United States of America versus Kelvin Otunyo, appellant. Mr. Madden for the appellant, Mr. Byrne for the appellate.
Right. Good morning, Mr. Madden. Whenever you're ready.
Please support. I am Jerome Madden, CJA counsel for Kelvin Otunyo. In the brief time I have, I'd like to talk about 3 procedural errors, 1 substantive error. We'll rely on our briefs for the Castigar issue. Defense level should have been 22, not 26. Advisory guideline should have been 46 to 57, not 70 to 87. The first procedural error, the court calculated the incorrect base offense level. Correctly grouped bank fraud and laundering together, and they correctly concluded that the most serious was money laundering, and therefore money laundering was the offense of conviction. The court incorrectly found the base level was 7 instead of 6. Defense level for an underlying offense from which 2S1.1A1 provides that the offense level for the underlying offense from which the laundered funds were derived. And the underlying offense was bank fraud, so it directs you to 2B1A1. And 2B1A1 provides 7 if the defendant was convicted of an offense reference to this guideline, and the offense is more than at least 20 years. Otherwise, it's 6. Reference to this guideline is defined in note 2, 2B1.1, and it provides, for purposes of this section, an offense is referenced to this guideline if this guideline is the applicable Chapter 2 guideline, specifically referenced in Appendix A, as determined by the provisions of 1B12. Money laundering is not an offense, it's an offense of conviction, but it is not listed under 2B1. Therefore, it's not an offense referenced to this guideline. So money laundering is the offense of conviction. It is not an offense referenced to this guideline, and therefore, the basic offense level should have been 6 and not 7. Feature error number 2, the court incorrectly added 4 levels of sophisticated conduct, but should have only added 2. The court added 2 levels for sophisticated bank fraud and 2 levels for sophisticated money laundering. This is double counting. Note 6, the 2S1.1, which addresses money laundering. It mandates that when money laundering is the offense of conviction, subsection C to 3D1.2, which addresses groups of closely related accounts, is to be used, mandatory. The court used subsection D instead, and that makes a difference. Subsection C provides that counts are to be grouped together when one of the counts embodies conduct that is treated as a specific offense characteristic in or other adjustment to the guideline applicable to another of the counts. Note 5, 3D1, explains what that means. Note 5 provides, subsection C provides that when conduct that represents a separate count is also a specific offense characteristic in or adjusted to another count, they are to be grouped together. This provision, quote, this provision prevents double counting of offense behavior. What that means is the court double counted sophisticated conduct should have only been penalized once. Procedure error number 3 is the court incorrectly added 3 levels to Otunyo's role in money laundering. The correct level is 2. The court enhanced by 3 based on conduct that dealt with bank fraud only, not to money laundering, and that is incorrect. The court said the record contains evidence not only that the defendant issued detailed instructions to Afalabi, but that he also provided suggestions and instructions to other participants, which were acted upon and affected the conduct of the bank scheme. This is error. Note 2C to 2S 1.1b states the relevant part. In cases in which subsection A1 applies, which is here, application of any Chapter 3 adjustment, which would be a roll adjustment, shall be determined on the offense covered by this guideline. That is, laundering criminally derived funds, and not on the underlying offense, which is
Mr. Madden, I'm not sure that I read the district court's decision quite the same way that you do. I mean, doesn't the district court also reference money laundering? I mean, some of the discussions are about bank fraud, but I think some of the discussion seems to go properly to money laundering. And the government's pre-sentence report also focused on this 3-level enhancement under the money laundering offenses, not the bank fraud enhancement. Yes. I mean, doesn't looking at that all together suggest that there may not have been an error?
Yeah, sure. I just want to point out that considering bank fraud is impermissible, the court did look at the money laundering aspects, but we look at the money laundering aspects, there's very, very little there that has to do with my client supervising anybody on the money laundering side.
Well, can I ask you about that? In the government's brief at page 44, they list what seems to me quite a bit of kind of managerial instructions that your client gave specifically to the money laundering, not to the bank fraud. Otunyo directed a co-conspirator to complete several debit transactions, issued several checks to co-conspirators to hide stolen funds. He directed a co-conspirator to set up a shell company and a bank account. He had co-conspirators deposit stolen checks. He issued checks to co-conspirators. He directed co-conspirators to help set up shell companies. There's a lot of like directing and instructing there.
Yeah, all of that, almost all of that, Your Honor, deals with bank fraud. If you look at the PSR, there are 58 paragraphs dealing with money laundering. Now, one of them has enough. Pahlavi was not directed to do almost anything. And I can go through that. I will go through those in just a second. They also.
The PSR is sealed, but I think I can refer to page numbers if you have it in front of you.
Yes. It's paragraph. Sorry, I don't have that. There are 58 paragraphs. I can find that for you if you like.
Well, so in paragraph 71 and 72, again, it seems like it's talking about a lot of money laundering, and it seems like he's doing a lot of directing.
Your Honor, at paragraph 37 in the PSR, he sent a message to Pahlavi containing a name of a false alias and an address. In paragraph 40, he told Pahlavi to obtain a tax information number for Novotel. In paragraph 41, he told Pahlavi to open a bank account. That is it. All the others, and there are many, deal with bank fraud. Where clearly, Otunyo was directing. He recruited a person, called person A. He gave her fake ID. He told her to open accounts. He told her specifically what to do in every one of those 15 paragraphs dealing with bank fraud, but that's not something you should consider. You're not supposed to consider for money laundering. That's
you mentioned was the name you mentioned?
It's the person's name was Walker. He recruited her. He directed, micromanaged her every step of the way, but it was all bank fraud.
What about? I just want to say the name if it's under seal. So. You referred to paragraphs 37 of the PSR. There's a person mentioned there in addition to your client. See that?
Yes, sent a message to Pahlavi containing.
Okay, Pahlavi. So, was that regarding the money laundering?
Yes, that's hardly enough to make him a manager. I mean, the case. If I made the case in this.
I mean, is your argument that there weren't 5 co-conspirators in the money laundering?
He might have been a co-conspirator, but he wasn't a manager.
It looks like he's managing Pahlavi.
Yes, for bank fraud, which is impermissible.
I thought you said this was the money laundering, Pahlavi.
No, Your Honor. Paragraphs there are 15 paragraphs dealing with bank fraud where Otunyo did retain, recruit a person and directed her every step of the way without any doubt. But on the money laundering side, he had very little direction of anybody. He's got 2 references to Afalabi, and that's it. And the court had an overbroad view of what it is to be a manager. Quote, there can be many, many managers and supervisors out of all those other people who are involved, who are convicted and subject to sentencing. But U.S. versus Graham, this circuit says, court found it did not discern any basis in the guidelines for enhancing the sentence of every participant in a conspiracy who does not reside in a bottom layer.
So can I now take you to JA 181? This is the plea hearing, where he pleads guilty and the court's asking him multiple questions. He says that I think this is all related to the money laundering. So you can correct me if I'm wrong. I'm at JA 181.
This is the sentencing transcript?
I think it's the plea column, the hearing where he pleads guilty.
I'm looking at page 181.
Okay, so it says you issued several checks to co-conspirators, including a debit transaction to Maryland Live Casino. Do you know if that's the bank fraud or the money laundering?
He may have issued checks to them. That doesn't make, that's not one act.
I know, I've got more. I just want to make sure we're talking about the money laundering.
Well, I'm not entirely sure here. I think the PSR is much clearer, but it's hard to say here. But
yeah, well, I won't go through them all then if you're not familiar with them, but the government's response brief talks about JA 181 through I think JA 196. And they say that it's regarding the money laundering and he's admitting to a lot of directing. So I guess do you have a response to that?
I do not have a specific response, but so my speculation would be strongly this deals with things. That's what he was really focused on.
Okay.
He was not a manager on the money laundering side. For example, in Graham, the court described what wasn't a manager. That one, it wasn't a manager because he didn't receive extra compensation. That's true here. He did not discipline lower ranking members of the conspiracy. That's true here. They did not alter the conspiracy policies or procedures in their respect. That's true here. Did not provide any guidance to senior managers and supporters. That's true here. Or otherwise held himself out as a link in the chain of command. And that's true here. At most, like as I said, he gave low-level instructions to Afalabi, give him an address, told him to get a tax information, a tax ID, and open a bank. That's it. And that's not sufficient. When you look at,
Mr.
I'll look at it again, but
I
you look at.
see that you're out of time. My colleagues have any other questions? Thank you. We'll give you a few minutes on rebuttal.
I have one more issue.
Well, but your time's up, so.
Thank you.
Mhm.
Good morning, Your Honors. Kevin, may it please the court, Kevin Burnett of the United States. I will just focus on the issues that appellant raised here at oral argument, so I won't touch on everything in the briefs. And I'll just start with the base offense level. So the base offense level is 7 under a very straightforward reading of the guidelines. And I think it's telling that appellant's arguments throughout the briefs and even here is based on a very convoluted set of cross-references and application notes that he is trying to string together to try to avoid a very straightforward text in the guidelines. So everyone agrees that these are grouped together. And then if you look at the...
Maybe I...
Sure, go ahead.
Just stop, but I want to come back to that.
Okay.
The thing that everybody does agree on, but I'm not sure.
Okay. So let's start at least from the premise for now then that these counts are grouped together. If you then look at guideline 2S 1.1, the base offense level for money laundering simply refers you to the guideline for bank fraud. It says that the base offense level is the offense level for the underlying offense. So whether we're talking about bank fraud, in which you would obviously go to 2B 1.1, or we're talking about money laundering, which just cross-references you back to bank fraud, you have to go to 2B 1.1. And 2B 1.1 says, under A1, that the base offense level is 7 if the defendant was convicted of an offense referenced to this guideline. An offense. Any offense that is referenced to this guideline. And appellant concedes bank fraud is referenced to 2B 1.1. He was convicted of it. There's no dispute about this. He falls within the plain language of A1. And there's no dispute about Part B, by the way, the stat max of 20 years or more. That word "an" is a very important word. He has been convicted of an offense. So appellant is trying to say, well, he was convicted of money laundering, so forget about the bank fraud. That's not what the guidelines say. They refer to any offense referenced to this guideline. And bank fraud is referenced to this guideline. And I think it's telling that appellant cites no court that has been faced with these facts that has adopted his position. The only court that has faced these facts has agreed with the government.
He does say that the sentencing, it's not the commission, maybe it's the commission. The probation officer here asked the sentencing commission whether everything you just said is correct, and they said no.
That's correct. And the government would disagree with the sentencing commission. And I think Judge Howell also disagreed with the sentencing commission in a very respectful way. She acknowledged that she has a lot of respect for the sentencing commission and the lawyers who work there, but that she disagreed based on a plain language, plain text of the guideline.
So, and I guess I'm with you, I think, with everything you just said. But I want to go back to where you said everybody agrees, which they do, that the money laundering and the bank fraud start out being grouped together. And the guideline that suggests that is 3D 1.2. You could maybe take a look at it if you have it.
I do, yes.
3D 1.2C. And it says when one of the counts embodies conduct that is treated as a specific offense characteristic in the guideline applicable to another of the counts, you group. Here, the bank fraud that he was convicted on happened after, a lot of it at least, happened after the money laundering. In other words, the money he laundered did not come from the fraud he was convicted of. Am I right about that?
Well, the separate counts that he was convicted under bank fraud are separate from the other money laundering schemes, I think is what Your Honor is getting at. So there are 4 schemes, and the first 3 schemes, which sustained convictions for money laundering, all happened before the 4th scheme, which sustained the convictions for bank fraud.
Okay, so bingo.
Right.
So in light of that, I'm not sure if 3D 1.2C applies, because it says you group when one of the counts, that would be the money laundering, embodies conduct that is treated as a specific offense characteristic in the guideline. So when the money laundering count embodies the bank fraud conduct, you group. But here, he wasn't convicted of the bank fraud conduct that is embodied in the money laundering conviction.
Right. So a few points on that, I think. I still think they group, but the government's position has been that they don't group under C, which is what Your Honor is referring to, and that they instead group under D.
Okay.
So D says when the offense level is determined largely on the basis of the total amount of harm or loss. And here, that is true to a large extent because under 2B 1.1, we have to add 12 to the offense level because of the aggregate harm. The proceeds that Mr. Otunyo admitted to obtain or attempting to obtain. And then there's some other language here which is not applicable. You group those offenses together.
Right. So let's say I agree with you on that, or tentatively agree with you on that. There's a note, I think it's note 5, and it says, of course, this rule applies only if the offenses are closely related. It is not, for example, the intent of this rule that a bank robbery on one occasion and an assault resulting in bodily injury on another occasion be grouped together. What's your argument for why that note does not apply to the situation here?
Well, just to clarify, is this note 5? Yeah. All right. So note 5 is talking about subsection C. Yes,
that's right.
Exactly. And then just to finish this point, to close the circle on this, if you look at subsection D, 2B 1.1 and 2S 1.1 are both listed in that subsection, so that they would presumably group together, as the district court did here. One other point that I just want to make on the base offense level. Well, actually, I think I should probably move on that unless there are further questions, because I see my time is running down a little bit.
I'm good.
Okay.
Thank you.
All right. So just moving on to sophisticated conduct and the double counting. So again, part of Appellant's argument here is relying on the C versus D distinction under grouping. He's saying this should have been under C. We say it's D. But one thing I want to emphasize to the court is that it doesn't matter either way, because the note that he is pointing to, application note 5, is talking about specific offense characteristics. And I want to use Rice, which is the case that he cites in his 28J letter, to explain why this situation is different. All right. So in Rice, all that Rice decided was that because the defendant in that case got an extra enhancement under the money laundering, because the drug offenses basically triggered that specific offense characteristic, that the district court erred by not grouping those together, okay? But what Appellant is trying to do is he's trying to say something different. He's trying to say that the enhancements have to group together, that the sophisticated laundering and the sophisticated means of bank fraud group together simply because the parent offenses group together. And that is not correct. There is no support for that in the guidelines. It would be correct if the bank fraud conduct and the money laundering conduct was the same conduct. But for reasons we've laid out in our brief, it is not the same conduct. Not only has been convicted of different, as Judge Walker pointed, different conduct in the bank fraud versus the money laundering counts, but even within the money laundering conspiracies, there's separate conduct in which he has sophisticated bank fraud and sophisticated money laundering. And I would point the court to Cabrera, which we cite in our brief, the 11th Circuit, which is on point shutting down Appellant's claim. In that count, same exact factual situation. Money laundering and bank fraud grouped in that case, and the 11th Circuit still applied both enhancements. And Kasim is another case that we cite, which has a shorter discussion of this, but does the same thing. It applies both enhancements. So the district court was correct that because there was separate conduct, Otunyo had separate conduct when he did the sophisticated bank fraud versus the sophisticated money laundering, both enhancements apply. I see I'm out of time. I can briefly address manager or supervisor, but I think Judge Rao and Judge Walker asked questions and made points that we would agree with and just expand upon. So if there are no further questions, we would ask that you affirm the judgment of the district. Thank you.
Mr. Madden, we'll give you 2 more minutes.
I would like to address the substantively reasonable sentence argument. I didn't get a chance to address because it relates to sophistication. So if we're right about sophistication, this is irrelevant. But if we're wrong about sophistication, then this is highly relevant, because under 3553, The court said, I'm going to give you a 2-level reduction because sophisticated bank fraud and sophisticated money laundering are one and the same. That's what she did. That's what the guidelines require. But if you don't think that is true, then what she did for Otunyo and what she did for OJ was a guy much more senior ahead of him who played guilty before he did. He had much more involvement. He had a longer criminal history. He took more money by far out of this whole scheme. And she gave him a 2-level reduction for because of double counting. Is exactly what we're arguing here. If you don't believe that, it's here. A couple more points. Part D, which deals with multiple counts, in the introduction says, when offenses are closely interrelated, and money laundering is always interrelated with some other crime. That's by definition. When offenses are closely interrelated, group them together for purposes of multi-count rules and use only the offense level or the most serious offense in there. What that means is, the DOJ doesn't want to follow the guidelines, but it says if you arrive at the offense of conviction, which is money laundering, then that is all you use for sentencing. Otherwise, this is a complete mess. I promise you, I've taken a lot of time with this, and it would be a mess. You have to read it literally, and when you read it with the notes, this should be remanded for sentencing. Thank you.
Thank you. Mr. Madden, you were appointed by the court to represent the appellant in this case, and the court thanks you for your assistance.
Thank you.
Case is submitted.
Case number 22-1076, Fontem US LLC petitioner versus United States Food and Drug Administration. Mr. Prince for the petitioner, Mr. Coyle for the respondent.
Good morning, Mr. Prince. Whenever you're ready.
Good morning, Your Honor. Thank you, and may it please the court. FDA denied Fontem's e-cigarette applications in this case for an alleged failure to satisfy the Tobacco Control Act's appropriate for the protection of public health standard. But FDA notably never concluded that Fontem's products pose any actual public health problem, notwithstanding that Fontem's tobacco-flavored product had been on the market for many years. Instead, they denied the application for alleged data gaps. But those data gaps were solely the result of FDA's flawed review process. Before getting to the merits, though, I would like to briefly address the elephant in the room, which is the effect of the court's or FDA's denial of supervisory review late breaking last Friday. We filed a new petition for review on Monday, which the court graciously acted on quickly and consolidated with our original petition for review. We apologize for the last minute filings, of course, but it was done out of necessity. But the upshot of that flurry of activity is, my understanding is the parties now agree that the prematurity concerns raised by the government in its response brief are resolved. And that is consistent with this court's past precedents in Bahamas County and Columbia Falls Aluminum, where a very similar situation arose and the court consolidated to resolve any prematurity concerns. As to the impact of the supervisory
No,
review.
Mr. Prince, you don't concede that there was a prematurity problem with your first petition, do you?
We do not, Your Honor. We stand by the arguments we raised in our reply brief. Having now done a very deep dive on these cases, I think a very interesting law review article could be written about the interaction of the incurably premature doctrine, the Supreme Court's recent repeated cautioning not to read jurisdictional requirements into the statute where Congress has not put them in there, and this court's recent clarification that finality in many cases, in fact, non-jurisdictional. But I don't think the court needs to address that in this case, because either we're right or the government's right. So this court has jurisdiction to review the marketing denial order. And in fact, a very similar situation came up in a case I'll provide, which we haven't provided to you yet. It's Collins v. National Transportation Safety Board, 351 F3rd 1246 from 2003, where the court was faced with competing petitions for review in an incurably premature situation. And it said, we just don't even need to decide this because either way we have jurisdiction and we would submit the same.
It does seem that it would be helpful to have a rule, though, for other companies in a similar position with the FDA. Maybe that's not your concern. But.
I don't dispute that, and protective petitions are filed in this circumstance frequently because I think the law is fairly unclear on it. But again, it is a fairly complicated issue and requires resolving a bunch of kind of late-breaking principles of law. So I would submit you don't need to do it in this case. As to the impact of the supervisory review denial itself, in Fonum's view, it has no impact on this court's review of the merits. Under the Supreme Court's decision in Locomotive Engineers, whereas here a request to the agency, if it can be considered reconsideration, was focused on error in the underlying order, the agency's order denying that request is unreviewable, unless the agency's formal disposition is to modify the order. And that's true, the Supreme Court said, and this court has also said, even if the order refusing reconsideration discusses the merits of the claims at length. Here, all the agency did was decline to disturb its underlying order. The supervisor said, I concur with the decision to issue the MDOs and thus deny your argument. So there was no reopening and issuing a new order in this case. It's unreviewable. Turning to the merits of the marketing denial order that actually is at issue in this case, I'd like to start, unless the court has a different preference, with our structural arguments, which we believe caused FDA to simply misapply the statute. Simply put, FDA has ignored all of the advance notice requirements that Congress put in place in the statute. Congress specifically set forth in 387JC the 4 criteria that FDA is to consider when evaluating an application, including whether the product is appropriate for the protection of the public health, and including whether it complies with manufacturing standards that FDA is obligated under the statute to promulgate. The delineation is important because Congress directed that specific problems be addressed in very specific ways, and the manufacturing prong is especially relevant here because I think it's undisputed in this case that FDA denied our application for manufacturing reasons. I mean, deficiency 2, deficiency 6, these are like literally in the heartland of what would normally be put in an FDA.
Can I give you an interpretation of the statute and you tell me why it's wrong? You look at A and it says the FDA can do individual adjudications where they balance and they figure out, is this product good enough for public health? Then B and D in particular allow the FDA to promulgate rules using notice and comment with regard to manufacturing and tobacco product standards. And the benefit of doing that to FDA is that when there is an adjudication, which is going to focus on the balancing in A, FDA won't even have to give an explanation if the tobacco product has violated one of the rules promulgated under B and D. So the FDA can do it one of 2 ways. They can either do it all under A and explain themselves, or they can promulgate under B and D, and then if B and D's rules are violated, when they apply A, all they have to say is, you didn't You didn't follow the rule that we promulgated under the.
I hear that, Your Honor. I have a few responses. One is there's always overlap between the prongs in these cases. In Justice Scalia's opinion in RAD LAX, for example, there was undoubtedly overlap between the prongs. And what the court said is, look, when there's overlap and one of the provisions is very specific and Congress has sort of gone out of its way to articulate a specific process, that needs to be honored. Here, the manufacturing provision in particular, it makes eminent sense that Congress would want manufacturers to have advance notice of things like what they need to test and what documentation they need. That's why we have such the lack of that is why we have such a fundamentally broken FDA review process. But it would be very odd for Congress to have said, okay, you must promulgate these manufacturing standards. By the way, you need to consult with technical experts when you do it. You need to give manufacturers grace periods to comply. All of these are to benefit manufacturers, not FDA. So I don't think the provision can be read as, essentially conferring on FDA discretion to do what it thinks it's best, right? It's avoiding procedural rights that manufacturers. So,
Counsel, let me try a simpler proposition. What, if anything, tell me, what does anything does the FDA say about the methods used in or the facilities or controls used for the manufacturer itself?
what does it say that means, or what is it?
No, what in their decision did they say? You're saying they rested on that, inappropriately rested on B considerations when rendering a decision under A, right? So what did they say about B considerations?
So a lot of so for example, many of the deficiencies are based on the methods and the documentation we have to map out our product characteristics, the testing against those product characteristics. For example, environmental controls, the humidity in storage rooms. This is all within the heartland of manufacturing regulations.
But it seems to me they faulted you time and time again for failing to produce something that they wanted or maybe newly discovered that they wanted.
I think that is
not for failure to comply with anything in B, but for failure to file information on which they could make a decision relating to B.
What B is intended to do is set out the processes and procedures that you need to follow to get to a position where FDA can make a decision. I would point your honors to the medical device context in the same statute, which is what Congress modeled this on. And there FDA has hundreds of pages in the Federal Register describing what you need to do. You need to keep controls for environmental controls. You need to do you need to have various sort of processes and procedures for stability issues. That's like, we are supposed to know to do that so that FDA can then reach a decision based on the data that we know we have to collect. And I don't even read FDA's brief, by the way, to be opposing our views that, for example, deficiency 2 could be considered under B. And I think FDA's argument is different. I think they've conceded it. I think FDA's argument is different. Their argument, as I understand it, is notwithstanding the overlap, we're allowed to do it under the public health prong as long as it raises some conceivable public health issue. But there's two problems with that. The first problem is that manufacturing standards, Congress put right in the statute, also address public health issues. So there's a much more specific solution as to manufacturing for public health issues that Congress has told FDA to use. And again, I mean, it's to me, this case is indistinguishable from RAD LAX. There's an overlap. The agency would prefer to use one criteria, but the other criteria is more specific.
Well, I think you're correct about the agency's view of the relationship between B and A. Whether you agree with it or a different matter, that I think is the position. Correct. That's the position they've taken. It may be that the straightforward reading makes it even easier than that.
I was just going to say that then if that is the agency's view, I submit that they have misapplied the law and the orders need to be vacated for the agency to apply the correct legal standard. And if it thinks some of these on reflection are not actually manufacturing issues, it's obligated under the APA to clearly explain why.
Mr. Prince, I think one of the, I'm sympathetic to your argument that, there are these 4 different reasons that they can deny the approval of an application. And so you can't necessarily put, one of these prongs into another one. But I think one of the difficult things about this statute is the approval authority allows FDA to require applications to have fairly specific content, right? To provide information on a whole host of different subjects. And so I think you need to have some account of how that content maps onto the requirement to have tobacco product standards or manufacturing standards. I think that interrelationship is very important to understand.
I think so too, and I think it's not a perfect overlap, but I think the application criteria, which Congress does spell out, actually map on pretty closely to the denial grounds. There's, I believe, one that maybe could fit into multiple categories, but otherwise, it's like literally using the same language, right? Submit information about the methods and controls for manufacturing, and then there's a separate version of the statute that says, okay, FDA, you can deny it when the methods and controls don't conform to your manufacturing regulations. So FDA did point to that relationship in their brief, but I just don't think it works. And it's creating superfluidity, as Justice Scalia said.
Well, so if they don't do standards, and yet their applications include things about, say, the methods and content of these products, how are they supposed to evaluate the things that are required in the application in the absence of standards?
Well, I don't think they can do that consistent with the statute. I think if they're going to deny an application for manufacturing issues, things that would fall within B, they need to first promulgate a standard because by definition, the statute says the ground for denial is a failure to comply with the regulation. The product standards argument is admittedly a little bit more difficult for us because that authority is phrased in more permissive terms. But let's suppose there is no statutory violation. Disagree with us on the statutory violation. FDA still would need to give very clear, as this court has said, reasonably certain to a good faith regulated entity notice of what the manufacturing requirements are. And we submit to not have reasonably certain notice of any of these requirements. And if you disagree with us on that, I would just invite the court to compare the high level of generality of the deficiency letter, which is frankly difficult for me to even understand in parts, with the clarity of the rejection letter, where FDA is imposing very specific requirements for very specific kinds of testing, telling us exactly, the kind of data we would need in many circumstances. So,
how does it work in practice? I mean, the FDA says that a manufacturer can file as many amendments as it chooses to an application in order to comply with a deficiency letter. So how does that work in practice before the ultimate denial?
Yes, Your Honor. So I think it helps to take a step back and look at the other regulatory regimes that FDA is implementing because they work very similar, where FDA is applying what is admittedly a broad statutory standard. And normally you're having meetings with the agency. There are many, many rounds of these kind of deficiency letters. The agency publishes product-specific drug guidance, device guidance. These are the type of environmental controls you need. So the regulated entities sort of know what they're aiming at. And then you're meeting with the agency throughout the year-long process. Is this study design acceptable? Is it not? And, I submit here that FDA, basically implemented for tobacco a regulatory regime without doing any of the prerequisite work to put in place a regulatory regime. But nonetheless, that's what it did. And the solution is that FDA needs to do the same kind of iterative process to make sure that regulated entities are getting fair notice. Really all we needed here was the opportunity to respond to the rejection letter. And we could have resolved the vast majority of these things. It's just information that, you didn't provide this one data point and we need it. That's all we needed to do.
I'd like to talk about deficiency 5, about the flavored products. So with respect to deficiency 5, the reasoning that the FDA gives for that deficiency is very similar to the type of reasoning that this court approved in prohibition juice last summer. And so I'm wondering how your challenge to deficiency 5, how would you distinguish that from the type of reasoning that this court upheld in prohibition juice?
I actually think prohibition juice is a nice comparison because the standard the FDA purported to be applying there was different than the one it's purporting to apply here, which kind of shows the shifting standards and the lack of noticed, but prohibition juice was fundamentally about whether FDA is allowed to do the sort of comparative comparison. Do you have to show not only that your product has a health benefit, but that it has a health benefit over tobacco? We're not disputing sort of that aspect of it, and we submitted longitudinal studies, unlike the prohibition juice folks, which we think demonstrate that. But here, FDA is sort of doing, it's a different kind of challenge. Our challenge here is grounded in cases like Pearson and City of Vernon, which the agency has set up a standard where it wants something quantitative in like the numerator, right? What is your benefits to adults? But the denominator is significant risk to youth, which nobody knows what it means. It's impossible to actually do like any comparison to tell whether you overcome the significant risk to youth, because it means whatever the agency wants it to mean. And this order seems to say, you can't do the comparison yourself, but we know the only thing that will overcome it is a device access restriction, which nothing in the history of the tobacco control regulation has ever been required. And FDA admits is novel and rare in this record. The agency can't just have a standard that is, I know it when I see it. This court's held that squarely, and we submit that's effectively what they've imposed in deficiency 5. I see I'm over time.
I've got a couple of questions. If I can direct you to deficiency 4, without saying anything that's under seal, what would you say to this argument? If you're going to use data from a previous product or a new product, you have to tell the FDA why every new aspect of the new product is immaterial. And with regard to one aspect of the new product, you did it.
So we understood the request to be to justify the product changes that we sort of reasonably thought could lead to a problem. And that's what we did to the agency. The agency knew about that one specific product design that you're talking about. It didn't specifically ask us a question about it. We personally did not think it was, the company did not think it personally was relevant, and so it didn't address it.
Well, go ahead.
I was just going to say, but it's fine if the agency is concerned about that. All it needed to do is ask us a specific question about it, and we would have told the agency.
Right, and I'm pretty sympathetic to the last thing that you said. If I were running the agency, I have no doubt I would have done that. But the question is whether APA and the statute here require it, and what they said in the deficiency letter is provide evidence to show that the changes do not matter. Changes plural. And you didn't address every change.
All I can say, Your Honor, is we addressed the changes that we thought we were relevant. And
what would you say to the argument that they didn't ask you to address the changes you thought were relevant? They asked you to address all the changes.
I would say the agency needs to speak so that we know with reasonable certainty what the requirement is. And that's not what we took that's not what we took the required to mean. I would also say, Your Honor, that deficiency alone is not a sufficient grounds to support these marketing denials.
So that's my last question. Assume I am with the FDA on the merits of deficiency 4, and I'm not with them on anything else. Tell me why deficiency 4 isn't enough for us to deny your petition.
Because the agency has not purported to claim that's an independent ground for one. Again, it needs to speak with, I think, with reasonable ascertainability that that's what it was intended to do, and that's not what the decision maker did here. It's also just fundamentally inconsistent with the test that the agency purports to be applying when it's doing a public health analysis, which is to weigh all the risks and the benefits contained in the application. And these are just statements FDA's consider the application as a whole. FDA declines to assign specific weight to any evidence. So if mere uncertainty about that one product characteristic, which, by the way, FDA never actually says is likely to happen. They just say, oh, we don't know. It's a little unclear. They would have to say and explain why that outweighs all of the numerous benefits that our products have that are stated elsewhere in the record, and it hasn't done that. I'll also note, Your Honor, that I think deficiency 4, at least in terms of what we're required to do to manage product changes and document and test against, would also typically be considered a manufacturing regulation issue under FDA's other regulatory.
You said one thing toward the beginning there where you said the FDA never said this was an independent ground, but they said would be needed. They said this is needed. Sounds like
would be needed to resolve the deficiency. I do not read them to be saying that the deficiency itself is an independent ground. And we are not saying, by the way, that it's inconceivable that FDA could ever have an order where there are multiple, if your product blows up in somebody's face, the FDA could clearly say, like, yes, this deficiency alone is so serious that it outweighs any possible benefit. But, uncertainty about a tiny little thing that changed in our product, it's a real stretch that the decision maker would have concluded.
So as a court, are we supposed to sort through that if we think some deficiencies are reasonable and supported by the statute and some are not? I mean, how do we decide?
I don't think that's your role just in generally under normal administrative law, but also in particular where the agency is applying a balancing test. That comes up in all sorts of other areas of the law, sentencing issues. I mean, if the agency has misconstrued the statute, if it's applied factors Congress didn't want it to consider, it needs to go back to the agency to redo.
Do you think that the denial letter contains at least a separate distinction between the flavored products and tobacco flavored products?
I do, and I think the agency's best arguments for independent ground would be on deficiency 5, in part because they could say, hey, we looked at this, we rejected it in prohibition juice, why wouldn't we reject it here? So that's FDA's strongest argument. I would submit that FDA has said you need to conduct a product-specific balancing of the risks and the benefits, and our record of benefits is not the same as in prohibition.
Counsel, a moment ago you referred to the many benefits shown in the record. Remind me just briefly, what are you referring to?
The major benefit is the significant reduction in harmful and potentially harmful compounds relative to combusted cigarettes, which is sort of the gold standard.
Doesn't that depend upon switching smokers from combustible to vaping?
Well, yes, I suppose there does.
And the agency said that's not documented in a sufficient way to amount to anything. So your offhand references to all these benefits is one of the very things being disputed.
I don't agree that the agency said that, Your Honor. I think they said specifically with regard to flavored products, we hadn't demonstrated sufficient switching effects.
Well, they certainly said that, and it did not say something comparable, you're telling me, with regard to non-flavored?
I do not believe so.
I think that's correct.
Okay. Thank you. We'll give you some time on rebuttal.
Thank you, Your Honor.
Morning, Mr. Coyle.
Good morning. May it please the court, Eric Coyle for the government. For 6 independent reasons, FDA reasonably determined that Quantum didn't meet the statutory public health standard to market its e-cigarettes, many of which come in fruit and dessert flavors attractive to kids. As FDA explained, despite the deficiency letter and the industry guidance, Quantum provided inadequate information about its product's health risks. This included information about emissions of substances like lead, formaldehyde, and nicotine, the risk of burn injuries, and the level of toxins and bacteria in the products over their shelf life. Before jumping to the merits, I would like to briefly address the effect of the decision on the supervisory review request. We've requested the opportunity to provide supplemental briefing on that issue. We got the other side's 28J letter on Monday evening, and so we would request the opportunity to provide the court with additional briefing. We do think that decision is properly before the court and can be considered at this stage.
What would be the point of the supplemental?
To explain what the effects of that decision are on the issues before the court.
Are there any?
Yes, we do think there are. We think
Other than the finality question?
yes, besides the finality question, for example, the questions about whether the grounds are independent. There are 7, I believe, separate pieces of support for that in the supplemental decision. We think it was clear from the original decision, but there's any doubt would be eliminated with the supplemental decision. There are also some additional arguments that they have made, for example, in their letter earlier this month referencing the Office of Special Counsel findings. To see how FDA passed on that, that would require the court to consider the supplemental decision.
Mr. Cole, how would it work if the first denial letter was incurably premature? I mean, how would this work in practice? I mean, the statute says that a party has 30 days to seek judicial review from the denial of an application. And then, so in this case, the quantum sought, filed a petition for review within 30 days, and then it sought an administrative appeal after that 30 days, right? So how does this work? I mean, would the 30-day timing for seeking a denial of an application be told if there was an administrative appeal pending? Is there some time limit for filing an appeal? I mean, the FDA's process is entirely informal. Perhaps there's some guidance indicating some timelines for filing an appeal. We were unable to locate any. I mean, just how would this work in practice? I mean, if you could just toll indefinitely, then the 30-day timeline in the statute would become irrelevant for filing a petition from the original denial.
I'd like to preface my answer by saying I don't think the court needs to decide that in this case. I think we've agreed the new petition is properly presented here.
Right, but your position is that the first petition was incurably premature, and I presume the agency may take that position in later cases. And so I just want to understand how the agency thinks this would work, given that the appeal process is not based in the statute. I'm not aware of any source of regulatory or even guidance that sets out the appeal process. I mean, how do those two things how does the appeal process interact with judicial review, which is clearly specified in the statute?
By analogy to the Hobbs Act, a filing of a petition for reconsideration before the agency tolls the statutory time to come to court and file a petition for review. But we think that would also apply in this circumstance as well.
Would a person have to file the administrative appeal within 30 days? Could it be at any time after 30 days?
I think if the petition for the reconsideration request were filed after 30 days, and there were also not a petition for review in this court within the 30-day period, then there might be a timing problem with coming to court afterwards. It might depend on whether the decision on reconsideration resulted in a new denial order or simply reaffirming the original.
But your answer just sort of reveals all the uncertainties for regulated entities in pursuing any of these paths.
Which is why I think this might not be the case that would be the best vehicle to decide that question.
Think of it this way, and tell me what you think. If the first petition is filed from an order that is apparently final, and then someone seeks reconsideration of that order, essentially making the first order non-final. We're waiting for the final order. Whatever the final order says, whether it addresses the merits or not, that would then be the final matter subject to a new petition, and the new petition would be added.
Yes, we agree.
Thank you.
How does that intersect, though, with the Supreme Court's ICC versus Brotherhood of Locomotive Engineers case?
Again, we would like the opportunity to brief this. We just got this letter on Monday night, and I'm not prepared to concede today that Brotherhood of Locomotive Engineers even applies to this circumstance. But even under Brotherhood of Locomotive Engineers, there is a distinction between a request for reconsideration that just rehashes the prior arguments and says the agency got it wrong. The denial of that is not typically subject to judicial review. And a petition for review that presents either new evidence or changed circumstances, the denial of which is subject to judicial review. And here, there are multiple examples of new evidence that Fonto presented in the agency reconsideration request, like the Office of Special Counsel report that just came out last month. That was never presented in the original one. That's something that the agency just had a chance to look at now. And so we do think even under locomotive engineers, that would be subject to review.
You're saying the record's different.
Exactly.
First petition dealt with one record, the second petition with somewhat different.
Correct.
Under your theory, what would stop the FDA from just sitting on the reconsideration request in order to preclude judicial review?
Good. So two responses. First of all, there's no requirement that a petitioner seek reconsideration before FDA, and many manufacturers have come straight to the Court of Appeals without seeking reconsideration. And there's also no suggestion, no allegation that FDA was anything but diligent here in resolving the administrative appeal.
With respect, I think I interpret you to say nothing. Nothing would stop the FDA from sitting on the motion, on the reconsideration request in order to preclude judicial review.
I think the agencies, in the agency regulation, there is no time limit, for example, limiting the agency's ability to decide, requiring it to decide within a particular time. But there's also nothing to prevent an applicant who is frustrated with the pace from withdrawing the application for supervisory review if they so choose to do so.
But we've had situations where, and this is typically after a remand, but it would be, I think, the same idea. The agency doesn't do anything, and the party then seeks under the All Writs Act, an order imposing a deadline, an immediate deadline on the agency. And I think the cases will show that it takes about 18 months before we will agree that the agency has been too sluggish.
I'm not familiar with that. Again, we got this letter on Monday night. We would like the opportunity, if the court is interested in this, to present supplemental briefing on the issue. If I can turn to the merits, and based on where the questioning went earlier, I'd like to start with the statutory argument.
Well, I have a question about that. It's the same question that I was pursuing with your opposing counsel. What did the agency say to the effect that the methods or controls used for manufacture, et cetera, do not conform to the requirements of 387FE?
So I don't believe that was the ground for the basis of the denial order here. The denial order here is
The agency said nothing about that, correct?
correct. The agency determined that this application
Said they didn't provide enough information for you to make a determination under A.
That's exactly right.
Thank you.
I'd also point out that the Act requires FDA to adjudicate marketing applications. The Act says that FDA is to consider a broad range of information when doing so, including about the product's health risks and manufacturing processes. And the Act requires FDA to deny an application when the manufacturer doesn't make the required public health showing under the appropriate for the protection of the public health prong.
So, Mr. Paul, maybe you can speak to that. What is the relationship between the content that's required on the application and how the FDA measures whether it's appropriate for the protection of public health, right? So in a situation where the FDA has not promulgated tobacco product standards and has not promulgated manufacturing standards, what do they do with this information on the application? I mean, what is it fair to ask manufacturers to demonstrate in these applications in the absence of any notice about what the standards are?
The statute itself puts the burden on manufacturers to make the showing that their products are appropriate for the protection of the public health, meaning the benefits outweigh the risks, considering the risks and benefits to the population as a whole. And the agency has, in this case, explained how each of the shortcomings in Fontum's application affect the public health in the end of the day. The emission of substances like lead, formaldehyde, nicotine.
Those are very granular things. So the statute for the adequate for the protection of public health sets out this risk-benefit analysis standard. But it also suggests that there are other prongs for denial where an application fails to meet a manufacturing standard or a tobacco product standard. So I guess I'm not sure why FDA thinks that it can effectively impose those standards under the broader public health umbrella.
So the agency is not imposing those standards under the broader public health umbrella. We agree with Judge Walker's questions earlier that manufacturing requirements and product standards, potentially allow FDA to deny an application solely for that ground, irrespective of the effects of that particular product on the public health. They're two separate prongs of the statute that FDA analyzes.
Well, they are two separate prongs, but I mean, the statute is very specific. I mean, it doesn't seem, I mean, I know FDA denies that they're in fact doing this, but if they, through the public health prong, say you haven't met a certain standard of emissions or, other controls, I don't want to mention any of the sealed material, at what point can they do that just under the general public health prong as opposed to through the notice that's required by promulgating a standard? I mean, the statute is very granular in what it requires for FDA rulemaking. There are very specific requirements for the type of notice that must be given, for the length of comment periods, for consultation with, the expert advisory committee, for delayed effective dates of standards. And I mean, that is very specific guidance from Congress about what FDA is supposed to do. So it does seem difficult then to impose those standards effectively through the public health prong.
The two responses, first one about the specific denial here, and then about the effect of the statute more generally. The shortcomings here were that Quantum didn't provide adequate information about its product's health risks to allow FDA to make the ultimate public health finding under the statute.
But that information is being judged against some type of implicit standard that FDA is considering, right? You're saying the information is inadequate for us to evaluate against some standard, a standard that has not been stated in advance through rulemaking that Congress required.
It is not here. The defects here were not that the application failed to show that the products met a particular manufacturing requirement or product standard. For example, the microbial stability data didn't exceed a certain level. That was not what the deficiency was. The deficiency was Quantum didn't provide the required information so that FDA could evaluate it at all and conclude that the risks were not outweighed by the benefits.
Yeah, but that information goes to some specific way that the FDA is going to evaluate the benefits and risks. So you can say it's a failure of information, but it's failure of information to make a determination under some standard, right? I mean, because the information is not just information in general, it's information to evaluate something specific.
And the specific is the statutory requirement that the product be appropriate for the protection of the public health, considering the risks and benefits. And it was relevant to the product's risks, the product's health risks to its users. The other response, more generally, talking about the statute, this provision still had independent effect. And I'd point out that the pre-market adjudication process applies only to new tobacco products, that is, products that were not on the market in 2007. If FDA wants to impose a requirement on a product that's not a new tobacco product, like a cigarette that was on the market in 2007, then manufacturing requirements or product standards would be the way to do that. And then they're also just the focus of the two provisions is different. One is looking at the product-specific effects on the population as a whole. That's what adjudication is. Whereas the manufacturing requirements and product standards are looking at the effects of imposing a requirement on a broader class of tobacco.
So is there any limitation on what the FDA can consider under the public health prong? Is it just sort of anything it thinks may be relevant to the risks and benefits of these products?
I think the FDA has to explain how the particular information is relevant, and FDA did so here, talked about why the level of microbes, level of toxins and bacteria can change in a product over its shelf life and how those can cause cancer and respiratory problems, for example. So I think FDA has to connect it to the bottom line public health standard, but the statute itself tells FDA that there's a broad range of information that it should be considering when doing that.
Has FDA promulgated any tobacco product standards or manufacturing standards under the statute?
I believe there is I don't know the latest status, but there is a product standard that would prohibit menthol in cigarettes, menthol flavor in cigarettes. I don't know the status of that. The manufacturing requirement, there's a proposed rule on the unified agenda. It's been pending with OMB since May of last year. I don't know any more information than that.
So just two.
I don't know. There might be more product standards. I don't know I don't know one way or the other.
Can I ask about, well, first I want to ask what the FDA meant in the order when it used the word need. So for example, it describes information about the temperature and humidity in the clean room as needed. Did the FDA mean that information is so essential that it will deny Quantum's request without it? Or did it mean that information would be maybe not essential, but really helpful to the FDA's consideration of Quantum's request?
I believe each deficiency on its own is independent. So all of the information under a particular deficiency would be needed in order to meet the standard, is what FDA said here. I think you can also see that from the...
So Quantum says that if that's the case, that would be arbitrary and capricious in itself to say that just simply leaving out the temperature of the clean room would justify denying Quantum's application.
That was not the sole basis of deficiency 3. It was not just temperature and humidity data. It's the entirety of deficiency 3 is the independent ground. That included information about accreditation certificates for testing labs.
So when, I think I'm following.
Okay.
And I think what you're saying is when the word needed was used with regard to the temperature in the control room, FDA didn't mean that information is needed in order for Quantum's application to be granted. It maybe meant it was needed in order for deficiency 3 to be satisfied.
I don't think that's right. I think the marketing denial order itself says that information would be needed in a subsequent application, not that Quantum can make a stronger showing in other areas to overcome that.
Well, then now we're back to my question, which Quantum raises in its brief. Wouldn't it be arbitrary and capricious for the FDA to say that the information about temperature in the room is so important to us that it's essential, and we're gonna deny your application if you don't give it to us? Wouldn't that be arbitrary and capricious?
I don't think it necessarily would be, but that's not the question here. There's more to deficiency 3. It includes...
Right. No, I know, but I'm making a hypothetical.
I don't think...
You don't think that would be unreasonable?
Temperature and humidity can affect the growth of all sorts of substances like bacteria, fungi, mold, but that's not the sole basis. I would also point, Your Honor, to the technical project lead review, pages 858 and 859. FDA explained that without each piece of information, FDA could not reach the bottom line public health conclusion.
Okay.
Those are internal documents, right?
I think they can properly be considered for a couple of reasons. I point you to JA 816. This is the first page of the technical project lead memo. It's issued on the same date that the marketing denial order is. And at the bottom, the decision maker for the marketing denial order signs the technical project lead memorandum saying he concurs with the recommendation and the basis for the recommendation. So I think it's properly considered as part of the agency's decision here. It's not a post hoc rationalization. It was decided the same day as simultaneous with the marketing denial.
Counsel, are you familiar with the GMP regulations for drugs?
I'm not familiar, Your Honor. I apologize.
Assume that I agree with you about the merits of deficiency 4. Assume I disagree with you about everything else, all the other deficiencies. What's your best argument for why we should agree with the FDA when it said deficiency 4 is alone enough to justify denying the application?
The two record places I would point you to are JA 858 and 859, where FDA explained that without the information in deficiency 4, FDA could not conclude that the products were appropriate for the protection of the public health, which is the ultimate statutory requirement that FDA has to find before it can grant. And second, I point Your Honor to JA 880 to 83, which includes the would be needed language that Your Honor was.
And then if I could ask,
And then, I'm sorry, one more.
That's fine.
We also think that the decision on the supervisory review request makes this crystal clear. Pages 3, 4, 8, 9, 10, or not 8, 3, 4, 9, 10, 12, 17, and 23 and 24. I think 7 separate places there. It's clear that the grounds are independent.
It's not surprising since that was done after this litigation. So where that was precisely the issue that wasn't in the initial order, it's not surprising that.
But the agency considered the arguments there and said, you know what, we think you're wrong, but even if you were right, we would come to the same bottom line decision.
Let me ask about deficiency 2 on the merits. JA 617 is under seal. So I'm just going to talk about paragraph. I'm just going to say it's the second full paragraph.
Page
617.
The second full paragraph or the second?
The second full paragraph. It starts with although.
Okay.
Why isn't that good enough to justify that Fontum's tests reflect the use patterns of the?
There's a distinction between the length of puff and the number of puffs. The deficiency that FDA found was on the justification for the number of puffs used. The paragraph you're referring to is about puff duration.
But it looks like number of puffs. Oh, I see. I think I see. Okay. I'll take a look at it more closely, but fair enough. And then my last question is on footnote 3 in the denial letter. Which is public. Yeah. JA 475. And Fontum makes this argument pretty clearly in its briefing. It says, here you are and just categorically imposing a requirement for device access restrictions when it comes to flavored e-cigarettes. And you can't just impose a categorical rule like that when absent notice of comment. When you say you're doing a balancing test and you've never told us about this categorical rule before. And so do you agree with Fontum that you are imposing an absolute requirement for flavored e-cigs to have device access restrictions?
No, we do not.
So why does footnote 3 not say that?
We're talking solely on the risk side of the equation here. This is a risk-benefit balancing test, and we're only looking at the risks to youth. And what FDA is saying is that it's got a lot of experience with the traditional sales access and marketing restrictions, like requiring somebody to show ID when they buy one of these products. And FDA's experience shows that that's not good enough to lower the risks because people get these from friends. Kids get these from their friends, not from buying them at convenience stores. And so the risks are going to remain high if those traditional types of sales access and marketing restrictions are the only thing that's proposed. Now, there may be a way to lower those risks if you have device access restrictions, like requiring a fingerprint to unlock it the way you unlock your phone. But FDA considers those in each separate application, and FDA hasn't enacted a requirement to have those. So that's just the risk side. Then FDA takes a look at the potential benefits to adult smokers and says, if you've only got the traditional sales access and marketing restrictions, you're going to have a high risk, so you need to show an even higher benefit to adult smokers. And that's where FDA looked at the specific evidence here and identified the shortcomings of each study that Fontum submitted, the inadequate sample sizes, the mixed results, the lack of a showing that their products were going to be more beneficial to adult cigarette smokers than tobacco flavored.
So would it be fair to say that unless Fontum can produce evidence that's never been produced before, that the benefit side is higher than we realized, that then Fontum has to do a device access restriction? Otherwise, the risk side is always going to outweigh.
FDA looks at each application individually. I don't think there is a blanket rule that would always require anything or other than that the benefits outweigh the risks.
But FDA has never approved a flavored application, a flavored e-cigarette product. Okay?
That's correct. There are still flavored applications pending with FDA. FDA takes a look at each of them individually, looks at the risks on one side, the benefits on the other. I do believe that there are, attempts to provide the types of robust and reliable evidence on the benefit side, and FDA is still considering those in each instance. They're considering applications that present randomized control trials and longitudinal cohort studies. There was none here. There was Fontum submitted a plan to conduct one of those types of studies and didn't provide any of the results or data from it. So FDA explained that that wasn't enough.
How does FDA explain, so its general course has been to proceed, as you said, individually through adjudicating these applications. I mean, Congress gave FDA the authority to regulate tobacco products, but arguably the Tobacco Control Act is a very detailed and comprehensive negotiated deal between protecting public health and the interests of manufacturers. And the interest of manufacturers is largely reflected in all of the rulemaking requirements that are imposed on FDA. So if all of these tobacco product concerns are adjudicated through the general public health prong, I'm just wondering how that is consistent with this very careful grant of authority that Congress gave to the FDA. I mean, I think it's just sort of like stepping back. I've read through the whole act carefully, and I do think that this general approach is hard to square with what Congress did here very clearly and plainly in the Tobacco Control Act.
I think the two provisions have independent effect. I talked about the new tobacco product versus not. I also agree with Judge Walker's questions earlier, which indicated that if FDA does go that rulemaking route, then it can deny an application solely for the failure to satisfy the particular rule without respect to the product's effects on the public health separately. So there are two independent bases.
But that suggests that the rulemaking is just a convenience to FDA. But that's clearly not the only purpose of rulemaking. The primary purpose of rulemaking is to allow for public input, to provide notice, to provide some clear standards that entities can attempt to meet. I mean, that's the main purpose of notice and comment rulemaking.
Yeah, I agree with that.
It's not a convenience to the agency. It's for the public and for private companies who are trying to market these products.
It certainly is, but once the rule has gone through that, then the failure to comply with that rule would be an independently sufficient reason to deny an application. The public health standard is a separate ground to deny an application. FDA has to consider the risks and benefits to the whole population that would come from marketing that particular product.
So your approach is to say, I guess, that the agency may proceed by adjudication rather than by regulation.
Not only may, the act requires the agency to adjudicate marketing applications, and it requires the agency to deny an application if it doesn't make the public choice.
That wouldn't work if the statute requires you to issue a regulation, which is what's being implied here.
They're separate sources of authority. I think there is still the requirement that the agency adjudicate marketing applications.
You say that they're separate, but they're also connected because some of the grounds for denial of an application turn on whether the application meets regulatory standards that the statute seems to assume FDA will promulgate. So, they're connected. And the language of the content of the applications is phrased in terms almost identical, or in many cases, in fact, identical to the statutory provisions requiring FDA to do tobacco product standards and manufacturing standards. So there there is an I mean, of course, FDA has the ability to adjudicate these applications, but that authority is very much connected in the statute, arguably, to the requirement for rulemaking.
There's certainly overlap, and that's because the way products are manufactured can have effects on the public health, on the health risks to users and the potential benefits. So there's certainly going to be some overlap. But we think the statute still requires FDA to decide these and to deny them when they don't make the bottom line statutory public health showing in the act.
Thank you.
Thank you.
Thank you, Your Honors. I thought I would start with the government's pointing out that the reconsideration or supervisory review denial addressed a memo from the special counsel's office regarding one of the letters under review. The Supreme Court in Locomotive Engineers said it's the formal disposition that matters of the agency order. You don't sort of read between the lines to see was the agency, the Supreme Court said, quote, in fact, doing reconsideration, it's the formal disposition. But I would note that even if the agency did effect a sort of limited reopening for that limited purpose, it would still be a mixed order that is almost entirely denying reconsideration and addressing that one specific new issue. And under this court's precedence, I'd point you to USPS v. The Postal Regulatory Commission, 841 F3rd 509. The part that's addressing the record that was before the agency before remains unreviewable, even if that small little sliver is then subject to review, in that case for abuse of discretion. We are not raising any challenge to the agency's consideration of the memo addressed in the special counsel. So I think it's just irrelevant to this case. I understand why the agency wants to get supervisory review denial in it, because there the agency actually did say that they're independent grounds for decision. But even taking that on its own terms, it's entirely unexplained. They just assert it. They assert it 7 times, but they never explain why that would be an independent ground, why it would be independently sufficient to tip the balancing test that the agency, when it benefits the agency, purports to be applying in order to discount benefits. But if it sees a flaw, then all of a sudden, it's no longer balancing. I don't think the court should accept that rationale. Judge Walker, you were focused on deficiency 4. Again, I submit that changes to product design should be set out in manufacturing regulations. So if you agree with us on that, I don't think you need to get to the issue that you were concerned about whether that one document purported to give us notice for public health prong purposes. And just in terms of the structural argument, Judge Rao, that you were talking to my friend on the other side about, and Judge Ginsburg, you raised this earlier. I do not hear the government to be walking away from the argument that it is free to pick and choose between the manufacturing prong and the public health prong. And the case law is abundantly clear it can't do that. In addition to RADLAX.
No, I don't think it said that. I don't think they're saying they're distinguishing between a violation of a manufacturing standard and a failure to provide information.
But Your Honor, the whole point of the manufacturing regulations is it's telling you the sort of information you need to collect. That is about processes and controls and requirements for documenting conditions, for documenting the specifications of your product and testing against them to see if they deviate. The medical device regulations are just replete with all of these kind of requirements, which then FDA flushes out on a product-specific basis with guidance. And so if FDA had put those regulations in place and had appropriate guidance, we would have known, for example, to monitor the humidity in various rooms in our manufacturing facility. But we didn't know until the denial order. So, but I understand the government to be saying it can pick and choose, and this court's already made clear and genus that FDA is not allowed to do that.
Is it part of your case that the government, that the FDA was required and failed to issue regulations?
Yes, I mean, it was, if it was going to deny us for issues that properly fall within the manufacturing prong within B, it was required to promulgate regulations.
So should we remand this case until, for them to issue their regulations?
You should vacate and remand this case, and if
For
FDA,
that purpose, so they can hold it until they get regulations out?
I think it is sufficient for you to vacate and remand this case, saying that the agency applied the incorrect legal standard and considered factors that Congress did not allow it to consider. The agency on remand can then decide, do we want to try and deny quantum on manufacturing grounds again, in which case it couldn't do it until it issued a manufacturing regulation, or if it's claiming to you here that these other grounds were truly independent, it could try and deny us on those grounds with proper reasoning that we would then be able to challenge in court as arbitrary and capricious.
Take a couple of years to get regulations.
I will note that FDA has denied thousands of applications for e-cigarettes, and as far as I know, we are the only application where it purported to address these kind of manufacturing issues. So I don't think it's going to create a big problem in the sense that you might be worried about.
Is product design the same thing as the methods used in the manufacture, processing, or packing tobacco product?
Yes, design controls are embedded within the manufacturing provision. And in fact, Congress specifically went to, FDA specifically went to Congress to have the ability to impose design controls added to the medical device provision. So now those provisions overlap. But yes, the sort of things your product needs to be able to do, the specifications, how you test against it are manufacturing.
This sounds more like a product standard.
I think there is some overlap between those, but FDA didn't do either here, so don't really have an opportunity. I mean, the FDA admittedly can try and distinguish, put some some meat on the bones of those two things and flesh it out with a reasoned decision, but we just don't have that. Thank you, Your Honor. I appreciate it.
Thank you, Mr. Prince. The case is submitted.
Case number 22-5071. I am appellant versus United States Customs and Border Protection, et al. Mr. Dubner for the appellant, Mr. Ward for the appellate.
Good morning, Mr. Dubner.
Good morning. Good morning, Your Honors. This case is about the Appointments Clause, one of the significant structural safeguards of our constitutional scheme. Appellant IM brought a claim under 8 U.S.C. 1252 E2B, alleging that the Appointments Clause restricts the issuance of expedited removal orders to appointed officers, and that because no appointed officer ordered him removed, he was not removed. But the district court dismissed the case because it believed Section 1252 E2 has an implicit custodial requirement. That was incorrect, as we'll explain today. The court then made a further error by failing to consider IAM's alternative argument that if there were a custodial requirement in 1252E2, it would be satisfied by the government's obstruction of his ability to file while in custody.
Why isn't the first argument ruled out by the limited jurisdiction we have with respect to review of these decisions?
The first argument, you mean in terms of the appointments clause piece?
Yes.
Or? So E2B gives jurisdiction over whether a petitioner was ordered removed. As this court said in Noel Canning, and a putative order issued in violation of the appointments clause is void ab initio. It's a nullity that never had any legal effect.
That's
So
okay,
therefore-
but our jurisdiction is specifically limited to certain claims. It's not one of them.
But yes, Your Honor, E2B specifically gives jurisdiction over whether the petitioner was ordered removed. Because no appointed officer ever ordered IAM removed, he was not ordered removed, and the court
He
has
was ordered
jurisdiction to
removed, but
consider.
not by an appropriate officer in your view.
Excuse me?
He was literally ordered removed, but not by an authorized officer. So,
No, Your Honor. The government presents the question as whether a piece of paper was handed out by somebody with the position of immigration officer, and that's simply not the operative question. The operative question is whether the United States or the person removed. The United States can only act in this capacity if IAM's merits claim is correct through an appointed officer. We would, point to the Dugdale case as we discussed as a good example of how this works. There's no question the government handed the petitioner in that case a piece of paper, and that piece of paper purported to remove him. However, the piece of paper had not been issued by a supervisor as required by regulation. The court said that arguably goes to whether or not the petitioner was in fact ordered removed, and therefore we have jurisdiction to consider it. It is certainly a narrow head of jurisdiction, but it goes to whether or not the United States ordered the person removed.
What about E5, the scope of inquiry, right? Which says that in determining whether an alien has been ordered removed under 1255B1, the court's inquiry shall be limited to whether such an order in fact was issued and whether it relates to the petitioner.
That's correct, Your Honor. We would argue, as we explained, that an order was not in fact issued. The court in Ryder, just a year before IRIRA was enacted, explained that a putative order issued in violation of the Appointments Clause is not valid de facto. De facto, there is no order that can have effect. And so, we believe that that's what in fact issued. Judge Cooper, in explaining the difference between his Dugdale and DAM decisions, one of which he found ordered removed to be properly invoked and one which he found it wasn't, explained that as petitioners must raise a claim that their removal orders were, as a matter of law, not issued. That's exactly what IAM is arguing here. To the government's argument that this actually should have been brought under 1252E3, we would disagree. First off, IAM is not challenging the constitutionality of the statute or any regulation or written guidance or written policy directive implementing it. He's challenging whether he himself was ordered removed. And there's nothing in E3 that takes away from the jurisdictional grant in E2. That's clear because there is naturally some overlap between some of those subjects. For example, the DHS has issued regulations about how to determine whether somebody who claims that they are not an alien or claims they have received asylee or refugee status is to be adjudicated. Those could have been challenged under 1252E3, but the fact that they could have been challenged under 1252E3 doesn't take away from the grants of jurisdiction in 1252E2A and E2C. Thus, the government's argument that somehow there's an unstated limit on 1252E2B is simply incorrect. And of course, Your Honor.
Mr. Dubner, didn't IM have filed his habeas petition while he was in custody? I mean, the arguments in the blue brief focus a lot on the fact that the removal order wasn't given to him until he was essentially out of custody and on his way back to his home country. But why was the removal order necessary in order to seek habeas? I don't understand that. I mean, he was in fact in custody and so could have presumably filed a habeas petition while in custody. I'm not sure what the removal order, how that affects, at least, his entitlement or jurisdiction for habeas.
And IM wasn't challenging his custody. He's not arguing that an appointed officer is necessary to detain somebody or anything of the sort, nothing short of issuing the removal order itself. His argument is that no appointed officer ordered him removed. He couldn't know if that was going to be the case until seeing who purported to order him removed.
Isn't
Up
it
until that
always
point, there was no violation.
Isn't it always the case?
It's not, I don't know if it's always the case or not in field offices around the country. There are some people who are appointed, there are some people who are not. We're not purporting to say this is something that is unique to IM by any stretch, but I don't know that this
And what
is
about
the case for
What
everyone.
about the practice around the country, and even in this office, subject office, with respect to when the order is handed to the deportee?
Yeah, we know that to be a practice, or we've been told, of course, that to be a practice in the Chicago field office operating out of O'Hare. We don't know whether it's the case in other offices, but certainly, that goes to this extraordinary circumstances question and whether or not it was in any way possible to file a claim before IM was released from custody. And this also overlaps with the question of whether there's a custodial requirement.
How's it an extraordinary circumstance that happens to everybody at O'Hare?
It's a fair question. An extraordinary circumstance is an unfortunate name for the doctrine of constructive
It might be an
satisfaction.
unfortunate doctrine.
Whether it's an unfortunate doctrine or not is a separate question. Of course, the government hasn't challenged the doctrine here. It hasn't denied that that doctrine is correctly stated by other courts, although, of course, this court hasn't reached the question. But the government hasn't disputed that if the government instructed him from filing, then that could satisfy the doctrine. The reason that I say the extraordinary circumstances name is a little unfortunate is because, of course, the government can't do something in every case with the intention of manipulating and thwarting jurisdiction and get away with it just because it does it so many times. If what it did here, and I'm sorry, it's extreme circumstances, not extraordinary circumstances. If the conduct here was extreme, it's extreme with reference to IM's ability to file rather than how frequently the government does it. But I think this overlaps significantly with the question of whether there's a custodial requirement to begin with, because Congress did intend that people would be removed immediately upon issuance of a expedited removal order. It intended for everybody who doesn't assert a fear of persecution for them to be out the door right away, turned around the next plane, or if they're in a car or on foot, turned right around at the border. And so Congress intended for there not to be custody. And yet we also know Congress intended for there to be jurisdiction over claims in E2. And so it doesn't seem like it could have been Congress's intent to have a custodial requirement here. That also tracks with the text of the statute. Unlike every other habeas statute we're aware of, there is no reference to custody whatsoever. Even more pointedly, there is no ability to seek or obtain a writ of habeas corpus. Congress, Judge Rao.
But he too seems to presuppose that there is some habeas corpus proceeding already. It doesn't read naturally like a separate grant of habeas jurisdiction. It seems to be referring to a habeas corpus proceeding that would be under, say, 2241.
I don't believe that's correct. And for a couple of reasons.
How would you read it as an independent grant of habeas? It says, that the judicial review of any determination made under section 1225B1 of this title is available in habeas corpus proceedings, and then has to be limited to the 3 grants.
Yes, and so I would give a few different textual reasons why that doesn't refer to the general federal habeas statute in chapter 153. The first is contrasting, what Your Honor just read in 1252E2 with 1252A1, which is the overall provision giving authority to consider petitions for review. 1252A1 specifically says judicial review of a final order of removal is governed only by chapter 158 of Title 28, except as provided below. That's how Congress cross-references other statutes when it means to incorporate especially jurisdictional, but when it means to incorporate the provisions of another statute. Congress did no such thing in E2, and that difference has to be significant. We, of course, take, your point, Judge Rao, and the government's point that Congress meant something when it said habeas corpus proceedings. But what it meant was proceedings, the form of the proceedings. Habeas corpus proceedings, as is well explained in the O'Brien case we cite in our reply brief, follow a completely different sequence and procedural structure than ordinary civil actions. Just to give a couple examples, Rule 12 generally doesn't apply by and large in habeas proceedings. The government doesn't need to respond to a petition at all unless the district court reviews it first, declines to dismiss it sua sponte, which is instructed to do if it finds no basis for relief, and only then orders the government to respond. Similarly, discovery. In an ordinary civil action, of course, parties move for discovery if there's no stay, or not move, but serve discovery requests on the other party, and they have to respond to them unless they move for protective order. In habeas corpus proceedings, no discovery can be served unless submitted to the court ahead of time and explicitly authorized for each specific request that's going to be served. So when Congress uses the phrase habeas corpus proceedings without authorizing the grant of a writ of habeas corpus, without referencing the general federal habeas statute, and in a context that suggests it knew that some of the challenges it was authorizing were going to have to come after an order, after the person was removed, I think it makes the most sense to read it as not having that kind of custodial requirement. And to the extent—
Do you think E2 is a separate grant of jurisdiction?
I do read it that way, Your Honor, yes. That is the only provision establishing how final orders of expedited removal can be reviewed. And so, yes, I do read that as a grant of jurisdiction, in part because if you look at it in the context of, I'm going to have to find the specific provision earlier in the statute. I'm not just flipping through it now. I'm not sure which one it says that no petition can be brought except as stated in E. But that is implicitly authorizing. It's taking away any other field of jurisdiction and granting jurisdiction in as stated in E2.
So you think the exception to a jurisdiction stripping provision is itself a grant of jurisdiction?
Excuse me?
So the exception to the jurisdiction stripping provision is itself a grant of jurisdiction?
Yes, I would say that, Your Honor. And I think E3 is another way of understanding this. E3, just like E2, says judicial review of determinations under Section 1225B of this title and its implementation is available in an action instituted in DDC. That's not saying that if you have an action under some other head of jurisdiction, you can also bring these claims. That's saying that courts can hear these claims in an action to bring only these claims. That's exactly the same thing that E2 is doing. I would also point to the extent that this is ambiguous. Of course, various canons of construction require it to be construed in IAM's favor. And the government, frankly, had it right the first time. The government in multiple briefs in multiple courts has previously argued that there is no custodial requirement. The government is, of course, entitled to change its position, but it's hard for it to credibly argue that this exact same language, this exact same statute without amendment previously meant there was no custodial requirement, now unambiguously has a custodial requirement. So at a minimum, the statute is ambiguous on the issue. And then you get to various canons of construction, the canon that jurisdiction stripping provisions are read narrowly, the canon that ambiguous immigration statutes are construed against the federal government, and the canon of constitutional avoidance.
You're not relying on the presumption of reviewability?
Excuse me?
The presumption of reviewability?
I would rather put it as the presumption that jurisdiction stripping statutes are construed narrowly, even when, and when they include exceptions to jurisdiction stripping, that those are given their full force. So I would put that a little bit differently. And again, of course,
I find the presumption of reviewability to be a very strange fit with the jurisdiction stripping statute.
It is, and yes and no. I mean, certainly there's no question Congress intended to strip jurisdiction of many claims. There's also equally no question that Congress did intend there to be jurisdiction over the claims in E2. The Supreme Court addressed this, not with E2 in particular, but about IRIRA in Husana v. Holder, It said many provisions of IRIRA were aimed at protecting from court review exercises of the executive's discretion, but no law pursues its purpose at all costs, and the textual limitations upon a law's scope are no less a part of its purpose. There is no question Congress wanted E2 to be usable. And in the vast majority of cases, given Congress's overall intent to get people out of the country without judicial review, to, in every case, avoid having people released into the interior, if at all possible, it wanted to get judicial review out of the way of removal. It wanted to cut down on stays of removal so judicial review could proceed. And so it had to want habeas to proceed on claims related to a removal order after the removal order was issued, at which point it expected people to be out of custody. So we think the text and the intent of the statute both point in this direction, even before you get to the canon, which we believe to be dispositive if the court gets that far. I know I'm over my time. If there are any other issues, I'd be happy to address them.
Thank you, Mr. Dugan.
And I've reserved 2 minutes.
Good morning, Mr. Ward.
Good morning. May it please the court. Brian Ward on behalf. Your Honors, the court should affirm the decision of the district court finding there is no jurisdiction over the habeas petition at issue. The text, structure, and history of Section 1225, which sets out the expedited removal process, and of Section 1252 all support the conclusion, first, that Congress didn't intend to grant jurisdiction in Section 1252E2 over a habeas petition brought by a petitioner who's already been removed, at which point there's no longer any detention to challenge. And even if the court doesn't agree with that, I think it's clear from the statutory text and the way the statutory structure is set up that Congress plainly didn't intend to provide jurisdiction in Section 1252E2 for an individual to challenge the process or the authority by which an expedited is issued. So in Section 1225 itself, 1225B, you have Congress saying plainly that unless an individual can raise an asylum claim, they should be removed without any further hearing or review. And then in Section 1252A2A, you have Congress setting out a near universal limit on jurisdiction to raise challenges related to the expedited removal process, saying explicitly that unless Congress reserved or authorized jurisdiction under Section 1252E2 or E3, and notwithstanding any other provision of law, there should be no jurisdiction for any court to hear a claim arising from or related to an expedited removal order.
So E2 allows you to bring a challenge to whether an order was actually issued.
It does not.
No.
Well, it allows you to challenge the fact of whether you received.
Whether you received an order.
Yes.
And
the Third Circuit said in the Castro case that the challenge is limited to whether you were given a piece of paper called an expedited removal.
What
or
if
whether it named.
What if a random name in the phone book handed you a piece of paper with your name on it, said, "Here's a removal"? Challenge that under E2?
So I think that would be a closer question than we have here, and I think that's the issue that.
So how is that different than an order signed by someone who is not properly appointed? Both of them have zero power to issue the order.
So I think Section 1252E5 says again that the question is a factual question of whether you were given a piece of paper called an expedited.
You just said,
Scope of
it might not count if it was some random person off the street who gave you the order and signed the order. I agree with you. And clearly that would not count as an order. So how is this different?
I think the problem with reading any authority to challenge the way in which the order was issued or any aspect of the process of issuing the order as part of what Congress was reserving in Section 1252E2B means that the limits on jurisdiction and the channeling of claims in Section 1252E3. So it's clear that Congress intended in Section 1252E3 that to be the place where individuals could challenge the way in which.
So this particular habeas petitioner, when could he have filed a habeas petition challenging the appointment of the person who issued it?
He could not have.
He could
So he couldn't. So in order to challenge the process by which the order was issued, or the authority, the constitutional authority of the immigration officers that issue these expedited removal orders. That sort of claim is a challenge to the system by which the orders are issued. Now would need to be brought within 60 days of when the process was commenced. Section 1225B itself.
There's some stuff in your brief that says, he could have filed a habeas petition while he was in custody before he got the final order. But I take what you're saying now, and I think I probably agree with you, he could have filed a habeas petition while he was in custody, but he couldn't have filed a habeas petition that challenged the appointment of the person who is going to issue the order.
That's correct, Your Honor. So there's two ways in which this case can be resolved. I think there is a custody requirement in Section 1252E2. There has to be some reason that Congress used habeas corpus proceedings in that provision. The opening language of Section E2 and E3 is nearly identical, except in E2, Congress says that judicial review of a determination under Section 1225B is available in habeas corpus proceedings. And then the immediately next following section, it says judicial review of a determination under Section 1225B and its implementation is available in inaction. Certainly, there are other differences between habeas proceedings and other actions in federal court, but I don't think any of them explain why Congress would have specifically chosen to limit E2 to habeas.
Imagine that E3 didn't exist, and I think that this kind of challenge could be brought under E2 if the timing was right. When could he have filed that petition?
I'm not sure I understand the question. Say that he could bring a claim under E2.
Imagine that I think you can bring a challenge to the appointment of the person who issued the order under E2. I know you don't agree with that. You think it has to happen under E3. Imagine I think it could happen under E2. When could that?
So a challenge under E2 needs to be brought while the individual is still detained.
So in this situation, on these facts, it could never have been.
No, so he could have brought a habeas claim while he was still detained. He was well aware that he was in the
But
expedited.
he could have brought it before the final order while he was still.
Yes,
If I'm right about reading E2 this way.
Yes, Your Honor. I still think
Separately, you think it would be ripe? No, he's challenging the appointment of a person who hasn't yet issued the order.
Well, again, I think there's a separate barrier to bring that challenge, even if you can bring a habeas challenge or a challenge to custody under E2.
And it may be that this doesn't matter and what I just asked doesn't matter, but why is the government's policy to not issue the final order, not put it in his hand until he's on the plane?
I don't know that there is a policy of doing that. I would say that in this case, the timeline was that he came in, he was detained at the airport, and he raised a fear of persecution. And there's a process under the expedited removal statute that allows that process to play out. You get an interview with
Maybe
the asylum
policy,
officer.
maybe policy is the wrong word, but assume it's the practice. This happens to everybody in this situation, at least at O'Hare. Why is that the practice?
I don't know that it's a standard practice, Your Honor, although I do think anecdotally it does often happen close to removal.
You know why?
But I think that the idea of the expedited removal statute, this court has held and the Supreme Court has held, is to quickly remove individuals once it's been determined that they can't raise a credible fear of persecution or an asylum. And so it's often close to when these people are quickly removed once they have a final expedited removal order. So it's often very close in time to when they receive the order that they're.
I think it's interesting the government suggests that this type of appointments clause could fit under E3 if it were brought within the 60 days. Because the regulation here says a number of different types of officials can serve as immigration officers. And as I read the regulations, some of those officials are officers of the United States. It's confirmed by the Senate, appointed by the president. So how could a person bring an appointments clause challenge within 60 days, not knowing whether their removal order would be signed by someone who was in fact an officer of the United States or by someone who was not an officer of the United States? I mean, how could they in fact challenge that until it was applied to them?
Well, I think the statute 1225B contemplates that immigration officers will sign these orders. And there's nothing in that statute that can be read to require appointment of individuals. And it's long been the practice
Well, it may be that the appointments clause challenge fails on the merits, but the government's position in its brief seems to be that type of challenge would be appropriate as a challenge to the system. And I'm just not sure how it fits under E3 at all.
So I think it would be a challenge to the system that permits unappointed immigration officers to issue these rules, which has been a practice that's existed
You wouldn't necessarily be able to raise such a challenge until you knew whether an officer or a non-officer was signing your removal order. Like the system or the regulation would not be facially invalid on appointments clause grounds. It might end up being, invalid as applied to a person, but not facially.
Well, I think that there were a number of expedited removal orders issued in the first 60 days after Section 1225B was passed. Those individuals could have raised an appointments clause claim or challenged the statute. And we know that part of the limits on the 60-day limit in Section 1225E3 was in place because Congress viewed this expedited removal system as very important as a process for dealing with a large number of individuals arriving in the United States. So it wanted any challenge to the system quickly resolved and resolved in a consolidated way.
So Congress could have avoided E3 review by just waiting 60 days before they deported the first person.
So this court has held in the MMV case that 60-day limit is jurisdiction. So a claim has to be brought within 60 days of when the policy first went into place. So that's not the allegation of what happened in this case, and there's no.
Very skeptical that an appointments clause challenge is a challenge to the system. I mean, maybe that the government prevails for other reasons, but this idea that an appointments clause challenge, which affects someone's individual rights, arguably is a challenge to the system, seems like a poor fit.
Well, I would say just generally, Your Honor, I think it's helpful to look at the legislative history here, and I think that it's hard to read the legislative history and what Congress was doing in enacting IRA to read it to Congress to be intending for there to be wide review or lots of opportunities for judicial review related to.
Right. I mean, the fact that you can't be under A3 doesn't mean that you get review of an appointments clause challenge under E2. It's just that you might not be able to get it under E3.
Yes, Your Honor. And if you could raise a habeas challenge under Section E2, those challenges obviously arise when an individual is dealing with their individual circumstances. So when they're detained, and they can be raised anywhere in the country. There aren't the venue limitations in E2 that there are in E3. So it would eliminate Congress's intent to consolidate and quickly resolve claims in Section E3. Individuals could just reframe any claim so that the process by which their order was issued as a habeas claim, raise it at any time, raise it in the district.
Other questions?
Thank you.
To pick up on the discussion that the court just had on the interaction between 1252E3 and 1252E2, Judge Rao, I believe, is correct that this is not a challenge to any of the subjects listed in E3. E3 is not about anything that might have broader consequences for the statute. It's specifically the constitutionality of the statute or the constitutionality or lawfulness of any regulation implementing it. Not a word of the statute or any 1225 regulations needs to change. IAM takes all of those to be a given. And if an appointed officer had done exactly what these unappointed employees had done, there would be no claim. IAM, of course, thinks they wouldn't have made the same errors, but that's not a claim he can review because 1252E2 is still limited to those three very narrow heads of jurisdiction. And that, I think, takes care of much of the concern the government raises for sort of escaping E3's 60-day time limit. Even if an E3 challenge could have or did succeed, that still doesn't allow an E2 challenge unless it fits within one of those three heads of jurisdiction. And as I explained previously, we believe this fits into E2B. Judge Cooper's DAM decision is a good example where the petitioners there were arguing their orders of removal were unlawful because they were issued pursuant to the transit bar, a regulation that had already been enjoined at that point. And yet the fact that they were outside the 60-day window meant even that plain unlawfulness was not a claim they could bring. So there's no real floodgates problem of all sorts of claims escaping E3. I would also respond to what my friend at the other table suggested, that Congress didn't intend these claims. Congress doesn't get to set the boundaries of the appointments clause. The Supreme Court has said repeatedly that neither Congress nor the executive may modify the prohibitions, the rules of the appointments clause. It said that immigration decisions such as these may be entrusted to executive officers. The government's
Congress can't change the meaning of the appointments clause, of course. But can it strip jurisdiction from the courts to consider an appointments clause challenge? That's really the question here.
It's not something Congress has ever tried to do explicitly, and so the court has never reached it. I think it would raise substantial constitutional concerns. And as you said, Judge Rao, in your Make the Road dissent, Congress, of course, cannot violate other constitutional provisions in the exercise of its control over jurisdiction. So at an absolute minimum, the idea that if no challenge was brought within a 60-day window in 1997, Congress is immunized for all time future appointments clause violations, that raises massive constitutional concerns for our separation of powers. And so to the extent that there's ambiguity, that should be construed in favor of jurisdiction here. If I could, I know I'm over my time for rebuttal, just to pick up on Judge Walker's hypothetical, if I could, because I think that is a useful thought experiment. And I'm happy to stop if the court would prefer. The question of whether or not a claim in fact was issued, and that's what E5 says, not did they hand out a piece of paper, but was an order in fact issued. If I purported to issue an order, there of course would be jurisdiction to say, no, the United States didn't authorize that person, no order was issued. If an IRS agent purported to issue an order, the courts would have jurisdiction to say, no, Congress didn't authorize that person to issue an expedited removal order, no order in fact was issued. Similarly, a CBP agent who had been fired a month before, the courts could say the executive didn't authorize that person to issue an order, and so no order in fact was issued. And then we come to this case. The Constitution does not authorize unappointed employees to issue these orders. And it can't be the regulatory or statutory challenge outranks the Constitution and changes the meaning of E2B. And suddenly it's no longer a challenge to whether an order in fact is issued. Thank you for the court's indulgence.
Thank you. Case is submitted.